Thank you for joining us today. This is EC Background's quarterly webinar series, and today's topic, 2017 Hot Topics in Employment Background Screening, is being presented by Pamela Devata. Pam is a labor and employment partner at Seyfarth Shaw LLP in Chicago, where she leads Seyfarth's National Background Screening, Litigation, and Compliance team. As a national authority and the firm's go-to for all issues related to the Fair Credit Reporting Act and background screening compliance, Pam participates regularly in media interviews, speeches, webinars, and training for employers. Pam has also testified before the EEOC regarding the use of credit checks in employment, is a certified Lean Six Sigma Yellow Belt, and was formerly an adjunct professor of legal writing at Chicago Kent College of Law. If you have any questions for Pamela during the presentation, please send them through the chat on your GoToWebinar, and if time permits, we will address as many as we can at the end of the presentation. With that, I will hand things over to Pamela.
Thanks very much, and thanks everybody for being here today. Thrilled to be here with EC Background to talk a little bit about 2017 hot topics in employment background screening. So welcome and thanks for joining us. As Megan said, my name is Pam Devata. I am a labor and employment attorney by trade, but for the past 17 years have really focused my practice on all things related to pre-employment screening, including the use of criminal and credit history in the employment and tenant screening context, and all things related to background checks and the Fair Credit Reporting Act. In the past 5 years or so, we've seen an enormous increase in the number of class action and single plaintiff lawsuits that have occurred in the area of the Fair Credit Reporting Act. So today we're going to focus on some of the lessons learned and some of the hot topics that you as employers are really facing under sort of the new schema, if you will, with some of the new recent developments both in legislation and in litigation to determine how you can really mitigate your risks and stay out of the fray by ensuring that you understand what's happening in the law. Real quickly, we've got a legal disclaimer. Obviously, we are lawyers and I am a legal counsel, but the presentation has been prepared by my firm and myself on behalf of EC Background for informational purposes only, and is not legal advice or counsel. Nothing that I say today should be intended to create or does create a legal attorney-client relationship. And if we do have time for questions at the end, any questions that we answer are going to be based on hypotheticals, and we're not giving legal advice or counsel. Happy to answer questions that you have, and hopefully we'll be able to get to many of them today. So what are we going to talk about? Let's sort of dive in and see. You know, we've got now a new administration. The dust is sort of settling, although there's something new, you know, every day. I was in Washington the last 3 days, and the energy is a little bit palpable there in terms of, you know, things that are happening all the time. That doesn't change in the area of background checks. So we're going to talk a little bit about how the new administration really, what we see happening, where we're seeing more lawsuits and new theories that really has grown from a recent Supreme Court case that came out last May. Now we've had about 9 months for the dust to settle there, and we're seeing really a split in terms of the types of authorities that are being lodged there. So I think it's right for that theory of when you are an employer and have a disclosure form likely to go back up to the Supreme Court. But we're going to talk about what the specific theories are, how those are being addressed, and how the courts are following them, and really what that means for you. We've seen a huge increase in adverse action lawsuits as well. We're going to talk a little bit about the best practices and where we see people fall and falter, and where we see companies getting sued on these. I actually think that the number of class action lawsuits and adverse action claims we've seen a huge increase on more of those just in 2017 year over year, because for a while all we were seeing were the disclosure claims. Little bit in terms of narrowing the workplace investigation exception. I'll tell you what the FTC has said about that in the last year. We're going to talk about ban the box, some of the new specific requirements, and they are constantly occurring We've got a number of state and local jurisdictions that have passed those laws, and then what more to come in the future, and if we read the tea leaves again with the new administration and in the next year, what we might see. So with that, we're going to go ahead and talk a little bit about what we're already seeing with regard to some trends of 2016 and the beginning of 2017. We are seeing more plaintiffs' counsels become involved. One of the reasons why this is because there are statutory damages that are allowable under the Fair Credit Reporting Act. We're going to talk in some detail about that. But much like Fair Labor Standards Act and wage and hour claims, plaintiffs' counsels can have one individual and bring a class action on behalf of that individual. The Fair Credit Reporting Act is a hyper-technical statute. There are very specific items and nuances that both employers as well as consumer reporting agencies have to follow. We're also seeing a consolidated effort by the plaintiffs' bar to share information and to join together in class action. It used to be that there was a little bit of a turf war, specifically in the plaintiffs' bar in terms of who would get a case and how someone would get a case. These cases are now so exponentially large in terms of exposure to a company that many of these cases, specifically as it relates to the disclosure claims, have been settling in the area of millions of dollars, right? So at the low end in the $500,000 range to the high end of $6, $7, $8, $12 million for companies. And so we've seen a lot of plaintiffs' counsels jumping on the bandwagon, some of whom are really just making copycat lawsuits, right? So you get sued once as an employer, and they go ahead and they file another lawsuit just to piggyback on, either with similar or the same allegations. We've had pretty good luck consolidating those lawsuits, but we are seeing a lot of forum shopping. What do I mean by that? We're going to talk about the Spokeo case, the Robbins versus Spokeo case that came down last May, and what the implications of that have been. It's interesting because the fallout from that, we've seen many, many, many more cases be filed, class action cases be filed in state court. The Fair Credit Reporting Act has what we call concurrent jurisdiction. So the FCRA says that a plaintiff or a group of plaintiffs can bring a cause of action either in federal court, because it's a federal statute, or in state court, which has had a lot of very unique jurisdictional and procedural issues that we've been fighting because of that. So if you're in California, we're going to see a lot more cases filed there, especially based on a new Ninth Circuit Court of Appeals opinion called Syed versus MM1. It was just denied rehearing, an unbanked rehearing, which would have been to go in front of the entire Ninth Circuit Court of Appeals just this week. We're also seeing some cases that, while we used to see a lot of cases be filed in Ohio and Pennsylvania, many of those cases are moving now to jurisdictions like Florida, where the interpretation of the Spokeo issue of whether or not someone has standing to bring a class action in federal court has gone both ways. So the dust is not fully settled, but we are seeing a lot of forum shopping continue. So what that means is that we've had to be creative as counsel of moving forums, moving venues, a lot of motion practice. And we're also seeing advertising. So it's not just the class action website and notices of those class actions that are being settled, but Facebook and other websites and advertisements, Craigslist, other types of advertisements saying something like, did you have a background check when you were hired for employment? Do you have any idea what that disclosure form says? Bring a copy and we'll tell you if you might be able to get money. It borders on the term ambulance chasing, if you will. So we're seeing a lot of advertising and solicitation, if you will, of plaintiffs to try and go after especially larger companies. We see a lot of claims being brought in the retail space as well as the staffing space. although really no employer who utilizes background check is 100% immune. And so we're going to talk about some best practices, what you can do to make sure that you're not the next potential class action. And then again, increase litigation on these issues. The reason why this is so important is because the penalties under the Fair Credit Reporting Act are very, very large. There are two types of claims under the FCRA. One is called negligent noncompliance and the other is willful noncompliance. We hardly ever see negligent noncompliance claims. Negligent noncompliance are usually a single plaintiff, one-person claim where a person was denied a job and claims that if they would have been able to dispute information in their report, if they were given a copy of their report, if they were given adverse action, for example, that they would have ultimately gotten the job. And or, for example, that if they would have been given a disclosure form that was not in violation or not, maybe they weren't given a disclosure form at all, for example. Negligent noncompliance means that you had a duty and you breached your duty, but it wasn't willful, it wasn't reckless disregard, it was just negligent. And what you can get, or what plaintiffs can get, is actual damages. That usually is back pay for the job, sometimes compensatory damages, that means emotional distress damages, and then attorney fees, meaning the fees that the plaintiff, the consumer, had to defend the case or bring the case on their own behalf. What we see much more often are allegations of willful noncompliance. It's a much, much higher standard under the Spokeo court case that was held in the Supreme Court a few years ago, and basically what it says is that for someone to allege a willful violation under the Fair Credit Reporting Act, you must be able to show reckless disregard for the law in order to be willful. It's a very high burden. But here's the rub. Instead of just getting actual damages, you can allege actual or statutory damages of $100 to $1,000 a person. And why that is significant is that class action defense counsel can often go in and say, you know, person A, person B, person C, all of their damages are different, and so this is not really right for a class action. They should be treated as different individual cases. And you try to fracture the class, saying that there's not commonality or typicality among the class members. If everyone is entitled to the same amount of statutory damages, however, defense class action lawyers don't have that argument anymore. That's why they're bringing these claims. Additionally, in addition to getting this attorney fees to defend or prosecute the case, there's also punitive damages and unlimited punitive damages. Those are very, very rare. We see them oftentimes. The only place we see them is in jury trials, and many times when they are exorbitant, those punitive damage fees are either taken out of consideration or overturned in FCRA cases. So there is definitely a threat, but it is limited. And so the key is, when you're looking at your exposure, let's take the two types of most common claims that we're going to be talking about. We've seen in the last couple of years claims against the employer alleging that your disclosure and authorization forms were in violation. Perhaps they contained extraneous information that we're going to be speaking about, or that you failed to follow the two-step adverse action process under the Fair Credit Reporting Act, for example. There are 4 responsibilities under the FCRA. Those 2 that I just mentioned. The other 2 are that you must also have a permissible purpose for running the background check. We've seen a little bit of an increase in those claims, but not really. Most of the time, if you're an employer, you have a permissible purpose, which is an employment purpose for employees and applicants and independent contractors and volunteers, at least as the FTC would interpret the term employment purposes. And then finally, you actually have to certify and make a promise to your background screening company that you're going to do those 3 things: disclosure, authorization, adverse action, permissible purpose, and that you're not going to run afoul of any EEO laws. So again, the biggest 2, disclosure claims and adverse action claims. And if you look at the statute of limitations is the earlier of 2 years from the date that the person knew or should have known, which is really when did they discover it, or 5 years from the date of the report. What that means practically is, let's take a disclosure claim. if you provided the person with a disclosure, but they're just claiming a technical violation, that the disclosure had extraneous information in it, for example, that's generally going to be a 2-year statute of limitations. So they should have known at the time you gave them the disclosure that it was, at least allegedly, in violation of the FCRA. So your exposure analysis would be, how many reports have you run 2 years back from any complaint, multiplied by $1,000 a person, plus attorney fees on the other side and potential punitive damages. And so it gets very, very large in terms of the damages provisions very quickly. Similarly, with adverse action claims, it depends what the allegation is. If the allegation was, for example, you just told me I wasn't hired and you didn't tell me I was hired based in whole and part of the background check, or you didn't give me a copy of my report or my summary of rights, perhaps that's a 5-year statute of limitations. It really depends on the circumstances, but you can see how the damages in these types of cases get extremely large very quickly. So where are we seeing the litigation? Generally speaking, starting in about 2012 with a case called Singleton versus Donovan Pizza and some other cases coming down afterwards, Reardon versus Closetmade, and then most recently that same theory alleging that if you have a release of liability in your disclosure form, that those forms do not comport with the requirements of the FCRA. So what does the FCRA say? It says very specifically that you must have, before you procure a consumer report, you must provide to the consumer a document, a disclosure in a standalone document consisting solely of the disclosure, the fact that you're going to run background checks. The statute also says that you must get the individual's written authorization. And then it says that you can actually combine the disclosure and the authorization. Very, very circular, poorly written statute, because what it talks about is, well, you have to have it solely the disclosure in a standalone form, but it can be combined with the authorization. So what we have seen, and we have seen, this started again in 2012, but really picked up critical mass in 2015. We saw a little bit of a pause while the Spokeo case is pending in the Supreme Court, and now we've seen even more floodgates after Spokeo came down last May of 2016. We'll tell you why. But much increased litigation alleging that anything that is not a pure disclosure that you're going to run background checks and authorization allowing someone to have background checks conducted would be extraneous, and that would violate the standalone disclosure requirement. What are some examples? The biggest one that what we have seen, and again, is the release of liability, holding harmless, release of liability in the disclosure form. We saw I'll call it a hybrid of this recently come out, especially after the Ninth Circuit Court of Appeals case ruled in the Syed case that any time that you have a disclosure that has potentially extraneous information, that violates a privacy right. So we're seeing, that case did have a release of liability in it. But the hybrid case that we're seeing is when the disclosure form specifically authorizes other third-party entities to provide information. The argument is that that's a release of a privacy right that the person had to maintain information that would be private, for example, education information or employment information, or courts providing information, although frankly courts providing information is public record. I absolutely do not view that is anything related to a release of any sort of liability. Indeed, it's not a release of any sort of right, although that's what some of the plaintiffs' counsels are arguing. Another argument we're seeing is that when you have state law information in your disclosure form, that is potentially in violation. Anything else, electronic signature language, if it is connected with an application, many, many years have gone by where we have already seen that, generally speaking, most people don't have their disclosure for background checks in a form that is in their application. But a lot of folks and companies have applicant tracking systems or application processes, whether they be electronic or otherwise, where there is multiple documents of information. I do think that you can still have an applicant process or system that has the application and perhaps other forms, but there's at least one court in the 11th Circuit that has held that anything that's part of an online application process experience, if your disclosure form is involved with that, perhaps it is not separate and complete. So what we generally recommend is to have a separate process in place. So you can do that a couple of different ways. One, you can put the disclosure form and then the separate authorization form, and we do often recommend that you separate those forms. Is it illegal? No. Does it make you not be the low-hanging fruit? Absolutely. So consider having a second path if you do it electronically. So, for example, you have an application system, and then after conditional offer, for example, an individual will go to your background screening company's candidate entry system and/or go to your own second path of your applicant tracking system that houses the disclosure and then separate authorization form, and/or with the offer letter, if you want a paper process or you want an electronic process where you email these documents, you email the offer letter and you have a PDF of the disclosure, a PDF of the authorization, a PDF of, for example, the state law information or other summary of rights documents that you need. Failing to provide the CFPB, the Consumer Financial Protection Bureau's summary of rights documents is a potential problem if you're doing an investigative consumer report. We've seen challenges when, arguing that the wrong name of the company is on the disclosure, so that there wasn't proper authorization. In using investigative consumer report. An investigative consumer report is nothing more than information bearing on somebody's character, general reputation, personal characteristics, or mode of living. But when you get that information, or your third party gets that information, and specifically only when your third party gets that information, based on interviews. So what's the perfect example? Reference checks. And again, not when you do it yourself, as the FCRA would not apply, but only when you have a third party doing the reference checks, like easy backgrounds, for example. That would potentially be an investigative consumer report, and that has very specific, different disclosures. If you combine those disclosures with the regular disclosure for a criminal background, those have been called into question, even though the FTC says perfectly fine and allowable. And then having your authorization be too broad, such that it may be an authorization of some sort of release. We've seen. Unfortunately, what we have seen is turns a little bit of a mixed bag after Spokeo with regard to how courts are interpreting what's extraneous, what's not, what's allowable, what's not. If you have not had your disclosure and authorization forms reviewed, we certainly recommend that you do it at least on an annual basis, and probably more times than that. We recommend that you understand that you are solely responsible as an end user, as an employer, for the veracity of those forms, and you want to make sure that if you're using a trusted partner or you're using something that you have found, you want to make sure that you get those forms legally reviewed by someone who knows what they're doing and knows this area of the law, because it is constantly changing and very much in flux. We're going to talk about how Spokeo has changed what a lot of companies are doing, and how the lawsuits are being come down, and what we're seeing in those in a few minutes. But now we're going to talk about adverse action. Adverse action is the second area of the Fair Credit Reporting Act that we see a lot of litigation against employers. So this law specifically requires that if you are taking action or thinking about taking action in full or in part based on information in a consumer report, that you must do a couple of things. First, prior to providing any information, prior to making a decision, prior to making an ultimate decision, you must provide a copy of the consumer report, the background report. You must provide notification of their right to dispute information, the summary of rights under the CFPB, and then any state law requirements. This is just under the federal law at this point, right? Then you must wait a reasonable period of time. The Federal Trade Commission has opined 5 business days to be reasonable, but understand there are different state law nuances about what is reasonable. So, for example, New York City requires 3 business days from the pre-adverse action letter to the adverse action letter. Philadelphia is the most restrictive. It requires 10 days between the pre-adverse and the adverse. And I should mention in New York City, you have to keep the job open for 3 business days. Other jurisdictions, you have to keep the job open between the 2 letters. San Francisco requires 7 days, but 7 calendar days is almost always 5 business days. So you have to make sure you understand what the timing is in these different jurisdictions. And then under the federal law, after you wait the reasonable period of time, you can then take adverse action. And there's a bunch of different things you must say in your adverse action letter. You have to give the person the ability to get another copy. You have to tell them they have the copy, ability to request. You have the ability to dispute the information additionally, and some other information that is very nuanced. What we are seeing, though, is that with the increase of the ban-the-box laws that we will be talking about, that there are now new requirements at local and state level that have made the adverse action process tremendously tricky. So to the extent that you outsource that adverse action process, you want to make sure that you understand what is being sent on your behalf and what is not being sent on your behalf. So to give you an example, San Francisco, Seattle, Montgomery County, Maryland, and Prince George's County, Maryland, Chicago, New York City, and others, LA now and Austin, all require, for example, that you say the specific reason why you are thinking about taking adverse action. So not just, dear candidate, enclosed please find a copy of your criminal background report or your background report. We're thinking about taking action in whole or in part on it. You need to say, for example, that it's the burglary conviction from 3 years ago that we're thinking about taking adverse action on in those specific jurisdictions. It makes it very hard to customize those and automate those processes. Similarly, in New York City and LA, there are now very specific required forms that you must fill out showing the individualized assessment analysis that you did comparing the criminal history to the job in question. You must provide that with the free adverse action notice. There's many others. New Jersey and Washington and Massachusetts have their own state law requirements. New York City has a ton of different requirements. It's its own process. New York State, New York Article 23A, and others. So we've seen a lot of challenges in the adverse action process. What we see a lot is employers who have wonderful processes in place in terms of dealing with their background screening company or sending out the letters, but the right hand's not talking to the left hand. And what do I mean by that? Generally speaking, it goes like this. You've got a wonderful process set up with your background screening company that when a person is has had a background check evaluated and we're thinking about taking adverse action, that we push a button in their system or our applicant tracking system, we move from one frame to another, and a letter is sent out. So one caution on that, make sure the language in that system, whether it's yours, your applicant tracking system, or your background screening company, you know what it says. And we recommend it say something like pre-adverse. Otherwise, there have been lawsuits alleging that the final decision was actually made at the time that you said do not hire or ineligible, for example. Even though all that really meant was send out the free adverse action letter, and if the person gives us other information back, we'll consider it. That was the case in Manuel versus Wells Fargo, which when there was an ineligible grade in the system, at least a court deemed that that could be deemed to be an adverse action if that's the only communication between the employer and the background screening company. So you want to be really, really careful about labels in your system. Pre-adverse. Similarly, let's say you move the person over from one bucket to the next bucket, which then that sets forth the pre-adverse action letter to be sent on your behalf, perfectly appropriate, but your well-meaning recruiter also then gets some sort of notification that the person is now ineligible. Well, they're actually really not ineligible until the pre-adverse action has been sent, the requisite period of time, whether it's 5 business days or some other based on state or local jurisdiction, has passed, and then the adverse action letter has been sent. I call it the no good deed goes unpunished. The candidate calls, the recruiter looks in the system and says, oh yeah, there's a problem with your background check. We can't hire you. You'll get something in the mail. Well, arguably, that communication could be deemed to be adverse action right then and there, prior to them getting the copy of their report, getting the pre-adverse action letter, getting the summary of rights, and having the waiting period. We also see the situation where it's the right hand, left hand, where I call it the Friday, Monday situation. A background check comes back. The person has been scheduled for work on a Monday. It's late in the day on a Friday, and there's no way that this individual can come to the orientation because they have some very significant job-related conviction that will cause the company concern in terms of a safety issue, for example. Assume it's job-related, assume that it's timely, and all the rest. If you call the recruiter, if you're a recruiter and you call the candidate and you say, hey, there's a problem with your background check, please don't come in on Monday, arguably the not coming in on Monday could be deemed to be adverse action. So what do we recommend? That you don't schedule a person until after the adverse action process is done. After the background check is fully completed, then you schedule a person. Or you schedule a person so far out that you don't have to reschedule and change. If you are in that predicament, a better opportunity would be to call the person and say, your background check is still pending. We can't start you until it's completed. We'll give you more information when we have it, for example. We also see claims on falsification. If you're taking action in more in part because somebody lied on a criminal history question, but you have verified that because of the background check, think about it. The background check could be wrong. There could be a mistake. The person actually may not have falsified or may not have lied, and so you may want to consider, we strongly recommend sending out the pre-adverse action when somebody falsifies as well. Auto rejection letters, we see a lot in terms of that applicant tracking system. You move someone over to the next bucket and they get a no thank you, and we've chosen someone else. If they've gotten that prior to getting the pre-adverse action, waiting the 5 business days or requisite period of time, and the adverse action letter, again, they've already been told that there's an adverse action. And sometimes we see it after the fact as well. Nobody likes to be told no thank you multiple times. So if you've already done the pre-adverse action, waited 5 business days and adverse action, then they have another automatic auto rejection letter from the applicant tracking system that usually doesn't sit well. Finally, we see this failure to send 2 letters. What I mean by that is a lot of companies will have a very well-meaning hiring manager or recruiter who will say, well, they don't need 2 letters, we're just going to tell them 1 time. And that, of course, defeats the purpose of the pre-adverse and adverse action requirement of the FCRA. The whole reason why you have the pre-adverse is a due process. It's because background checks have mistakes in them, and the legislature knew that they were not going to be perfect. So it gives the person an opportunity before they lost a job, before any adverse action was actually taken on them, that they would have the opportunity to dispute information in the report. The good news is, on the Robbins versus Spokeo case, and we talk about that, that there have been some really good cases that have held if the information in the background report is correct and accurate and the person would not have disputed it anyway, what really is their harm from not getting the letter? You still want to follow the process, but there's at least some good procedural arguments that we have in that system as well. Which leads me to the last point on adverse action, which is, to the extent you hire individuals prior to having a background check complete, please understand there's a lot of risk there if you decide to remove them from work prior to the, or between the pre-adverse and the adverse action. The reason being is because, obviously not paying somebody who's already started work is going to cost you money. So you want to put them on a leave, and then you're going to have to pay them arguably for 5 business days. It's also much, much harder to terminate someone from a morale standpoint, from an overhead cost standpoint, et cetera, than to withdraw an offer of employment. So the best practice certainly is not to run background checks, not to place someone until after after conditional offer of employment and after that background check has come back and is completed successfully, so that you don't have that risk. Very, very briefly, there's one section of the Fair Credit Reporting Act that's called the Workplace Investigation Exception, and my firm actually wrote this into law in 1997. It talks about the fact that if there is a policy, written policy in place, or there's a federal or state regulation that requires that a background check be run, then that could fall into the exception of a workplace exception. So here's the reason why it really went into effect, which was lawyers, for example, are third parties. We don't necessarily see ourselves as consumer reporting agencies, but if we're getting information and doing a harassment investigation or a theft investigation, we don't want to have and didn't want to have the employee tipped off by getting a disclosure and authorization that there was going to be an outside party come in and do this investigation. That's what it was really made for. Many companies used it and frankly tried to swallow the rule, basically saying, well, I have a policy that we don't hire people who have certain convictions, and so that's why I'm running the background check. Certainly the FTC came out with some information last year. Basically they said, look, the title is employee investigations. It doesn't deal with applicants. It only deals with employees. And it's a very, very narrowly construed exception. So don't utilize that for all of your applicants, certainly, and I wouldn't utilize that for all of your employees as well. Ban the box is the next big thing. We have seen, starting in 2012 with EEOC criminal history guidance and use of conviction and arrest records in employment, a huge increase in the number of laws. You'll see here, these are for private employers. If you are a public employer or if you have government contracts, there are other laws that will apply to you. These specifically require or restrict when an employer can ask about and possibly what a person can ask about when it deals with criminal history. It's more than that, though. And as I said before, some of these ordinances talk about the analysis that you have to do. Some of these ordinances talk about the fact that you have to put certain things in the pre-employment, in the pre-adverse action letter, for example, like the San Francisco and Chicago is actually the adverse action letter, and many others. LA, of course, is a big one now. And LA, Los Angeles is actually not on this list, but because it's not fully enforceable at this point in time. It is in effect. It went into effect in January, but it will not be having enforcement provisions against it until July of this year. So understand that it's still in place as well. Some of these ban-the-box laws have restrictions on when you can ask about the criminal history, meaning you can't ask about it on an application, just generally. Others of them have restrictions on when you can ask about them and after an interview or after you tell a person that they're eligible for an interview, for example, like Illinois and Minnesota. Massachusetts actually says you can't have it on the application, but the MCAD, the Massachusetts Commission Against Discrimination, interprets that to mean at the time of the interview. And still others, the most burdensome is many of these jurisdictions require or restrict someone both from asking about criminal history and from getting that information anywhere until after conditional offer. Those include Hawaii, for example, Washington, D.C., you've got Columbia, Missouri, New York City is the biggest one, New York City and L.A. New York City is perhaps one of the most stringent laws that you have. It requires many, many specific items and restrictions. First and foremost, you're not allowed to mention criminal history, ask about it, or tell a person that a background check will be done in any way, shape, or form until after conditional offer. What that means is job postings, applications, even getting the disclosure and authorization prior to conditional offer may be in violation of New York City law. And the New York City Commission has taken a very broad view of that. Understand that ban the box not only applies to the application, it can have very specific restrictions on when you can ask that question. In addition to the ban the box laws, there's a whole myriad of other laws that talk about criminal history. So California has exceptions on what you're allowed to ask about and when. They just came out with new regulations with their fair employment housing regs that just came out earlier this year. You've got Connecticut, who doesn't allow you to ask about erase records or null records. A myriad of other state laws that have restrictions on field, expunged, impounded, erased records, for example. And then other laws have time limits on how far back you can ask. For example, San Francisco, 7 years back, and other jurisdictions have different time limits for how far back you can even ask about criminal history or get criminal history when you're evaluating it. So ban-the-box is a really very sticky issue. We're seeing a lot with the new administration. I don't think we're going to see as much on the state level. Austin, Texas has a bill in Texas right now that could potentially make Austin, Texas's bill go away and be preempted by a state law if it passes. California has a law, same thing, that potentially would preempt the laws, and because there's San Francisco and California, San Francisco and LA, that may be significant as well, but those have not been passed as of yet. We saw the CFPB and the FTC, both of the regulators, really going over and doing a sweep of the industry last year in 2016. With the new administration, it'll really be interesting to see what the CFPB does. There's a case law that is calling into question whether or not the CFPB was actually set up in a constitutional manner. But in addition, those of you who've been reading the news, there are bills that are trying to gut the CFPB and do away with it altogether. I don't think those are going to pass, but you never know. So more to be seen on the CFPB and the FTC, especially with the new administration and what they're going to be doing. But what that often means then is there's a gap and there's more enforcement rulings and by the plaintiff's bar. So when your regulators aren't going to be doing this, then what you often see is the plaintiff's bar filling in that gap and filing more lawsuits, which of course no one likes because it makes it a lot more risky for all employers. We've spent the last few minutes talking about the Robbins versus Spokeo ruling and how that applies and what that means in terms of some of the things that you might be doing specifically with your processes and policies and how that affects it. So the Robbins versus Spokeo ruling is sort of a procedural, makes a procedural conundrum for defense lawyers and plaintiff lawyers with the Fair Credit Reporting Act. And the case basically said, it went up to the Supreme Court and basically said, does a plaintiff, does a person need a true injury in fact to have standing to bring a Fair Credit Reporting Act class action in federal court? There was a split in the circuit, so it went up to the Supreme Court. The oral argument was November 2nd, and the ruling was May 16th of 2016. Basically, what the Supreme Court did was, after we had a vacancy on the Supreme Court, but there were instead of 9 justices, there were 8 justices. Then, of course, what happened was we thought that there was going to be a tie, but instead, the court actually decided to say, you know what, Ninth Circuit Court of Appeals, you didn't really do your job. You didn't do your analysis. We're going to send it back. The actual case has not been decided back down in the Ninth Circuit Court of Appeals yet. We're still waiting to see what that says. But the fallout of the ruling basically is not definitive. So basically there's really good language that says there must be particularized injury and concrete harm in order to bring a claim. So some of the courts have interpreted that to mean in the adverse action context, look, just because we didn't give you the pre-adverse action letter and didn't give you the adverse action letter so you had an opportunity to dispute the information, because remember, that's the reason why you provide that. It's the opportunity to dispute the information. If the information in the report was accurate, you wouldn't have had any ability to dispute the information. So how have you been harmed? On the converse, in the disclosure cases, we've had half of the cases go one way that say, wait a second, you knew a background check was going to be run. Just because state law disclosures were in the same form of the disclosure, how in the world is that any sort of violation? We don't think that gave you any harm or particularized injury. On the other hand, certain jurisdictions, like in Florida and in the Ninth Circuit Court of Appeals, have said you have a privacy right to certain information, and by not getting the rights that you were supposed to be given on the disclosure form in a standalone document that is an informational injury or invaded your privacy. So it's very, very interesting because what we have seen is really a conundrum of these cases being filed in state court on a nationwide basis. Not sure, but I will tell you that most defense counsels don't like to litigate, and particularly most plaintiff counsels don't like to litigate a nationwide federal question of a federal statute in the middle of a state court in the middle of the country that could potentially impact an entire nationwide class. And that's what we're dealing with right now. We're also dealing with splits where some cases are going up and they're having jurisdiction, or the cases are being dismissed, or then they're being remanded. There's a couple cases that are on appeal right now looking at that. So it's a procedural nightmare. It may result in inconsistent results. Certainly, if you've got certain state court judges in the middle of the country making rules on a nationwide class versus the federal courts somewhere else in the country looking at that same issue, there's potential for some real inconsistent results. We are looking here, again, the dust is not settled. So instead, what's happening is plaintiffs are looking for the best forum. They're looking specifically to see where I can bring this case, for example, that's what they're thinking, where it won't go back down to state court. Or, how about this? Let me put it where I know it will go back down to state court because the defense counsel don't want to be there, for example. So a lot of things going on. Again, a mixed bag of cases. Spokeo doesn't only apply to the FCRA, it applies to many, many other cases. And I told you before, this new sort of privacy injury theory that we're seeing on and on all over the country. So far, we've had a couple of circuits who have said that there is an informational injury or privacy injury, and a couple of circuits who have said that there are not. I should say a couple of district courts. No circuit court has ruled that yet. It may be right for another trip to the Supreme Court on a little bit different of a question. So not whether or not somebody has standing, but more importantly or more significantly, I think, whether or not there is any sort of informational injury or privacy right if in a disclosure and authorization form. Additionally, we may see some new regulatory guidance. The FTC and the CFPB in this new administration, they want to make themselves vital. They may want to be communicating guidance and either through consent decrees or through regulations or through publications or other settlements so that they can make themselves be useful, if you will, when they're being evaluated. We don't think that's really going to happen a lot right now, given President Trump's orders to sort of stand down with what people are doing at this point. We might see additional investigations if they're ongoing investigations that have not been interrupted by the President's orders. Definitely, we're going to see more litigation. We've already seen that. We've seen that specifically in state court. New, very unique, different issues and theories. Strongly recommend that you get your disclosure and authorization forms reviewed often, that you understand, that you separate them from other items of the application process, that you consider separating them from themselves or anything else so that you're not the low-hanging fruit when a lawsuit potentially is lodged. I think we're still going to see more plaintiffs' counsels. These are easy claims to bring. There's not that many defense counsels that really focus and specialize on this, although it's growing a little bit just to deal with the need of the plaintiffs' counsels. And then again, new theories that we are seeing often crop up with these allegations. Certainly in terms of best practices, we absolutely recommend that you train your hiring managers, train your recruiters, train the people who are evaluating the background checks, ensure that you have somebody who knows what the laws say in terms of the ban-the-box laws, who's evaluating the checks. So especially if you're in LA or New York City, those are the most stringent. Make sure you understand those requirements so that you don't have either the attorneys generals or private rights actions against you. We're seeing a lot of these claims being lodged in the Human Rights Commission and other regulatory at the state and local level as well. Review your disclosure and authorization forms and understand what your adverse action process is as well. And with that, I am going to turn it over back over to Megan. And if we've got questions, we've got about 8 minutes left. If you do have a question, I strongly encourage you to type it in the chat button, and we will go ahead and try and answer those. Megan?
Yeah, we currently don't have any questions, so if you do type it in here pretty quickly. There was one question about having access to the recording. Yes, Easy Backgrounds will have this up in their blog in the next day or so, and we will email it to you directly too, so you will have the recording. I'm still not seeing any other questions coming in, so Pamela, I think you've done a very thorough job today, so thank you for all the great information. We did have a question. It says, we are a nationwide staffing company. Do we follow the laws of the state residence, state where the job is, or state where our corporation is?
Yeah, great question. And the answer generally is you should follow the law where the applicant lives in or will be working, because that's generally where they are going to have jurisdiction to sue you. So you want to make sure that you are following the laws that they need to be protected by, which is, again, generally speaking, where that person lives or works, with a small exception of Massachusetts. Massachusetts laws sometimes also protect the records, but that's really more for background screening companies. So where the person can live or work.
Perfect. I haven't seen any other questions come in. If anyone does, feel free to reach out to Easy Backgrounds. Oh, we did have one more. Credit information when not getting credit. Can you explain it?
Yeah, so one of the things that I mentioned on some of the trends with credit information when you're not getting credit. So, for example, New York City has a new Stop Credit Discrimination and Employment Act that says it's a violation to mention credit if you are not going to be getting credit. And so that's going to be a potential violation under the New York City law. Additionally, there are 10 states and 2 jurisdictions that have credit requirements or restrictions. And so if you're in one of those states that doesn't allow you to get credit, and you say that you might be, you want to be very careful about that, because there's a claim that a person may incorrectly think you're getting credit because the disclosure form says so. In New York City, you're going to have 2 forms. You're going to have a credit form and a non-credit form.
We had another question come in, Pamela, on the use of electronic signatures, and if it's all right to go ahead and use those.
So the answer is, generally speaking, yes. You've got the Unified Electronic Transactions Act, which is UDA, which 47 of the states have signed on to, and then you've got the E-Sign Act, which really covers the other 3, New York, Washington, and Illinois. And basically, if you're going to use electronic signatures, you want to get the person's consent to use electronic signatures in the first place, and then you want to actually get their electronic signature. It's about provability, but the Federal Trade Commission and the CFPB have specifically said that there's no reason you cannot have a disclosure and or an authorization sign signed electronically. Be careful that you don't have a lot of the extraneous consent to sign something electronically on the disclosure form, or somebody might argue that that's extraneous.
That is all the questions that we had come in. Again, we'll provide all of the attendees with a copy of the recording today. Pamela, thank you for your time and all the great information, and thank you to everyone for coming to the presentation. We hope everyone has a great rest of the day.
Thanks, everyone.